Welcome to Employment Law This Week. I'm George Whipple. As we move into the reopening stage of the pandemic, some employers are looking to mobile technologies to ensure a safe workplace. Epstein Becker Green's Adam Forman and Karen Mandelbaum tell us more.
Mobile technologies such as apps, wearables, and other innovations can play a prominent role in employers reopening in a manner consistent with the health and safety of their workforce and customers. This mobile technology can assist employers with contact tracing, enforcement of social distancing, temperature checks, and health questionnaires. Finally, this technology can also provide employers with information about the health of their workforces to support their efforts to reduce exposure to workplace liability.
Employers should consider technologies that every employee has access to and that are easy to use. If not everyone in an employer's workforce has access to a smartphone, then an app is probably not a good choice. The main goal that an employer should want to achieve in choosing a technology is to help employees feel comfortable knowing that one of the steps that their employer has taken to make their workplace as safe as possible is providing them with this tool that will help them and tell them that they may have been exposed to the virus.
As with any new workplace technology, there are a host of legal risks to consider when implementing COVID-19 mobile apps. There are, of course, employment law issues ranging from wage and hour, such as whether time spent on temperature check or pre-work questionnaire apps is compensable, to ensuring that the technology is accessible for employees with a physical or mental impairment, to traditional labor law issues, such as whether technology is a mandatory topic of bargaining and whether using it constitutes unlawful surveillance. There are also OSHA and workplace safety issues. Finally, there will certainly be health, privacy, and security issues.
Before an employer decides to rely on a third party, the employer should make sure that the agreement with the technology developer is only collecting the information specified by the employer to be collected, that the information will only be used for the purposes that it was intended for collection and not for any other secondary uses. And the employer should also consider that they shouldn't keep the data any longer than is necessary.
Transparency should be the watchword. Employees may be apprehensive about returning to work, and employers should be open about steps they're taking to address any concerns. Employers should also take a measured approach. These technologies are new. Some may not work as intended, and others may present unintended consequences. It's important that employers do not overstate the capabilities of any of the tech. And employers should monitor the effectiveness early and often, and course correct as warranted.
Ultimately, we're asking employees to make a trade-off, to give up some of their privacy interests in exchange for protecting public health. If we're careful, we will achieve a balance where our workplaces will be safe and people will be able to trust that the personal information about their COVID status is being properly respected.
Thanks, Karen and Adam, and thank you very much for watching. Stay safe out there, and we'll see you next time.